We now turn to the second case in this evening's docket. That is case number 115434 LCL LLC v. James W. Phelan et al. Appellants v. Rice County Abstract and Title Company, Appellees.
May it please the court. William Denning on behalf of Rice County Abstract and Title. Mr. Chief Justice, I would like to reserve 3 minutes for rebuttal.
3 minutes is granted.
Mr. Chief Justice and Associate Justices, we are here tonight because the Court of Appeals ignored and misapplied well-settled Kansas law in holding that the 2-year statute of limitation did not bar the Phelan's claims for negligence and breach of fiduciary duty against my client, Rice County Abstract and Title. In a well-reasoned and thoughtful opinion, the trial court originally granted summary judgment in favor of my client, holding that the 2-year statute of limitations barred their claims. The Court of Appeals reversed that decision, and in doing so, they ignored this court's precedents and well-settled Kansas law about when the statute of limitations begins to run.
Counsel?
Yes.
Can we just go back to the beginning a little bit on this? And I'm specifically interested in the way that you moved for summary judgment originally. Did that motion include facts about not only when the deed was filed, the 2008 deed was filed, so when the negligent act supposedly occurred, but when the injury occurred? Not just the negligent act, but the injury, because they're distinct, aren't they? At least theoretically distinct.
I think they're theoretically distinct, Your Honor, but I think they're one and the same. The date the deed was filed, our argument at the Court of Appeals.
That's your legal position. That's your legal position, right? I believe as the summary judgment pleadings went back and forth, one of your responses to your esteemed opposing counsel was that when he said we never lost possession of our mineral interest, you said that's a legal conclusion. So I think that what's good for the goose is also good for the gander.
Well, and I think there's a difference between possession and ownership, Your Honor. And
Right.
That's the distinction that we drew at the trial court level, is that when the deed was filed on January 18, 2008, as a matter of law, the Phelans lost ownership of that property.
Let's explore that for a moment, the as a matter of law part. There's no dispute here among the parties that there was a mutual mistake.
There's
right?
not, Your Honor.
There's no dispute. And if, in fact, there was a mutual mistake in the conveyance, then that deed was subject to equitable reformation, wasn't it?
It could have been, Your Honor. If it would have been timely brought, yes, it could have been.
Okay. And one of the things that, as a matter of law, can cut off that reformation is a bona fide purchaser. But again, there's no dispute here that the second purchaser in 2014 was aware that there had been no intention between the parties in 2008 to transfer that mineral interest, right?
There's an email or a statement in terms of the correspondence that he does represent that he understands that the mineral rights are not being transferred with the property. That's correct, Your Honor.
Okay. Well, given that we have this property law, basic property law, about the ability to reform a deed that's filed and contains a mutual mistake or records a mutual mistake in a real estate transaction, how can we say, as a matter of law, that the injury, be it substantial or actionable, whichever term you want to apply to it, occurred at the same time that deed was filed, as opposed to sometime later when the opportunity to reform was no longer available?
And because I think, Your Honor, the reason you can say that that injury occurred on the date the deed was filed is because of this court's jurisprudence. The case law in this court is that when a deed is filed and it doesn't include information reserving an interest, such as a mineral interest, that mineral interest then transfers to the subsequent purchaser. So in this case, it transferred from the Phelans to Mr. Dean upon filing of that deed. You can also look at Kansas statutory law, which says, and I believe it's KSA 58-2202, that if a deed does not contain a reservation, it passes full title to that property. And that's why the fact of injury would have occurred when that deed was filed versus some time later on, because regardless of whether there was a mutual mistake, ownership of those mineral rights were transferred to Mr. Dean upon the filing of that deed. The Phalens could have walked down to the courthouse the very next day and filed a claim against Rice County saying, we lost the ownership of those mineral rights.
Let me ask it a different way. In 2014, when the deed was made to your client, or to LCL, if your client had checked the record correctly and discovered the true ownership, discovered the reservation, included that in the deed from Dean to LCL, would we be here today? LCL would not have had a claim to those minerals, would it?
Correct, Your Honor, but I don't think my client could have unilaterally altered the deed once that property had already been transferred to Mr. Dean. I don't think my client, Rice County, has the ability to say, we found this
Well,
mistake.
they tried to correct it. They tried to get a correcting deed.
They
But
did.
what I'm saying is that Mr. Dean wasn't asserting ownership. Mr. Dean knew that the intent of those two parties to that contract was that he didn't get the minerals, he didn't assert the right. He would have lost in a reformation case because he would have to say, hey, I know I didn't buy it. I didn't buy it. And so the Phalens didn't lose ownership vis-a-vis Dean, because between Phalens and Dean, they knew what their agreement was and they were all on the same page. Where the problem arose is when you brought a third party in with the incorrect or failure to discover the mistake in 2014. So why isn't that when the injury occurred?
Because they lost the ownership right as a matter of law by this law of
If you
Kansas.
could file a reformation action and retain your ownership, how did you lose it as a matter of law?
And Your Honor, I don't know what would have happened if they would have filed a reformation. There was actually a quiet title action between LCL and the Phalens, and the Phalens chose to settle that action.
You're missing my point there. That's bringing the third party into here.
Right.
I'm saying that when the third party was brought into this is when the trouble arose for the Phalens. As long as it was Dean and the Phalens that made the agreement and made the sale there, everything was all okay. It was when Dean brought a third party in. And so I'm still not understanding why that isn't the point where it changed everything.
And I would disagree with Your Honor that the point that became an issue for the Phalens was when you brought the third party in. The issue for the Phalens was once that deed was filed on January 18th. That's when they lost ownership. The Court of Appeals went through a history about transfers that the Phalens attempted to make with this half mineral interest ownership. All of those transfers are void at that time because they didn't have ownership of the property. So they were attempting to exercise dominion, they were attempting to transfer the property, and they couldn't do it. So it's not that their injury occurred when LCL refused to transfer the property back to them. Their injury occurred when they lost ownership of the property, and that was January
They didn't lose the
18th.
entire ownership of the property, because as we learned in property class, there's the bundle of sticks.
Correct, Your Honor.
They retained part of that bundle
They
in the
did.
form of royalty checks every month, or whatever they were paid. So they still retained part of the bundle of the ownership, didn't they?
They did, Your Honor. And Your Honor, I would point the court to Sutton versus Sutton, which is a Kansas Court of Appeals opinion, where there was a divorce action, and the wife thought that she was going to be deeded the property, and she remained on the property when it was transferred back to her mother-in-law. She remained on the property for a period of time, so she had the use and enjoyment of the property. When the mother-in-law died, she found out that the property was not going to be transferred back to her, so she filed a cause of action against her husband, trying to bring the property into the marital estate. And the Court of Appeals held that the date she lost the property, the date she lost ownership, was when that property was transferred to her husband and she wasn't included on the deed, and that her cause of action accrued at that time, even though she continued to live on the property, enjoy the land, and profit from the land. The fact of the matter is the Phalens did in fact lose, when we talk about the bundle of sticks, the key bundle, the key stick, which is ownership of that property. At that point, they no longer had the right to transfer the property. In fact, they no longer had the right to receive those royalties. Had Mr. Dean chosen to do so, he could have asserted a right to those mineral interests and to those royalties had he chosen to do so, because the right to the royalty arises out of the ownership of the mineral interests, because we have two distinct property interests there, a real property interest and a personal property interest. And that was part of the error that the Court of Appeals had, is they focused solely on the royalties.
Am I
You're saying
looking
the
at
royalties are personal property, but we're really talking about the minerals interest.
We are, Your Honor.
One half undivided interest in the minerals, and that's corporeal property, real property.
And we are, Your Honor, and that was the problem with what the Court of Appeals' analysis was, is the Court of Appeals focused solely on the loss of the royalties when they determined that the statute of limitations began to run in August of 2014, and they tied that directly to the loss of those royalty payments.
Even if we accept all of that, why isn't there a new act, a new injury in 2014 when the transfer to a third party is made and the right to reformation ends? That's a new act, a new injury. And you may have other legal defenses besides statute of limitations to all of that, but based upon the allegation that your client should have notified the Phalens of their mistake earlier before that third-party transfer occurred.
Because, Your Honor, I don't think the act which gives rise to the injury occurred in 2014. The act that gave rise to the injury was the filing of that deed on January 18th. Without that initial act, the purchase in 2014 by LCL is irrelevant. There's no injury during that but for what happened in 2008 with the incorrect deed.
I understand there's a thread there, but isn't there a new injury in 2014?
Your Honor, I would disagree.
act?
Your Honor, I would disagree that it's a thread. I think it's a rope. You don't get to 2014 absent the injury in 2008. If the deed is properly prepared in 2008, when Mr. Dean transfers the property to LCL in 2014, there is no injury. So the act giving rise to the conduct, which is what KSA 60-513 tells us to look at, is the act giving rise to the injury occurred in January of 2008. The injury was the loss of ownership. And that's why it all goes back to January 18, 2008, when that deed was filed.
What damages occurred as a result of the loss of ownership under your theory during the statute of limitations period? They were receiving the royalties. They had to pay. So what cause of action existed at that time?
Well, Your Honor, I think in the record it shows what they sold the property to Sammy Dean for, which was $203,000, I think. Obviously, that $203,000 did not include the value of those minerals. Separate and apart from the royalty payments. Had they been selling the minerals too, presumably they would have asked for more than $203,000. In fact, that's exactly what the Phalens asked for in the petition that they filed against RCAT, Rice County Abstract and Title, was the value of those mineral interests. They could have walked down to the courthouse the day after that deed was filed and filed suit against RCAT for the loss of the value of those mineral interests because they no longer owned them. And that was one of the injuries that they suffered. The other injury that they suffered, Your Honor, was the fact that they no longer had control. One of the bundles of sticks that we talk about in property is the fact that you can dispose of the property. As I said, they attempted to transfer the property a number of times. Those transfers are void because they didn't own the property at the time they were trying to transfer those mineral interests. So they also
But
lost.
they were effective at the time. You say they were void, but they were effective at the time, and they effectively transferred the minerals interest, did they not?
I would disagree.
Didn't the grantees under those conveyances then come into proportionate share of the income off the land?
And Your Honor, the record doesn't reflect that at the Court of Appeals. My argument would be is that they weren't effective because you can't transfer title to property which you don't own.
But everybody behaved as though they were. Everybody behaved as though it had been done properly until 2014, which is what brings you to Justice Lukert's question about, wasn't 2014 a new ballgame once they introduced a new player?
And Your Honor, I think that the context of the case changes when you add a new player, but I don't think that changes the analysis as to when the injury occurred. The fact that LCL asserts a claim in 2014 is not a separate and distinct injury from what happened in 2008.
Why can't a negligent act produce multiple injuries that don't occur simultaneously? And isn't that what foreseeability is all about? That you can commit a negligent act that doesn't manifest itself in an injury until sometime in the future, perhaps far into the future. And you will be liable for that only if that injury is foreseeable.
And Your Honor, I think in this case, the fact that they lost ownership in 2008 makes it reasonably foreseeable that somebody in the future could assert an interest to those royalty payments. So I think that was a foreseeable injury that occurred when the deed was filed. Secondly, my response to that would be, Your Honor, is it's the fact of injury, not the extent of injury, that starts the statute of limitations running in this case. And that's this court's jurisprudence. That's well-settled Kansas law. And the fact of injury was the loss of ownership in 2008.
Do you deny that in 2014, when your client was handling the LCL sale or purchase, that your client committed professional negligence by failing to discover that there was a problem with one half of the minerals on this property?
Your Honor, I don't think my client failed to discover that in 2014. I think the record reflects that they did, and they tried to correct that problem with LCL.
So there was negligence that occurred because they issued the deed. They issued the deed before they discovered the problem.
And Your Honor, I don't think that's a separate act of negligence that would apply to the Phalens in this case. And the reason it wouldn't apply to...
Was it negligent? Was it negligent to prepare the LCL title opinion? They issued a title opinion, and if I'm a purchaser of the property and your client gives me a title insurance and says it's whole, and there's a half undivided interest that's floating out there that's subject to litigation, I'm thinking you committed professional negligence. Do you disagree with me?
Your Honor, I would not say that what occurred in 2014 was necessarily professional negligence because the deed that had been filed in 2008 didn't reflect that mineral interest. The way my client discovered it, I think...
But you don't look at deeds. I've done a lot of stand-up title opinions. You look at the property taxes, you look at the appraiser's office, you look at all kinds of other documents in the courthouse besides just the deeds, and there were plenty of indicia that the Phalens were getting paid for these royalties, weren't there?
There were, Your Honor.
And I'm expecting my abstractor to find those. And you're telling me that you don't think that was negligent to fail to see that the Phalens were getting half the royalties?
Well, first, Your Honor, in the 2014 transaction, Rice County Abstract and Title didn't act as an abstractor for the Phalens. It acted as an abstractor for LCL and Mr. Dean. So if there was a negligence there, presuming that there was, that negligence doesn't apply to the Phalens. It would apply to Mr. Dean or to LCL, who were the parties to that transaction, because the Phalens were strangers to that transaction at that time.
But that's a different defense than the statute of limitations. We're just trying to hone in on the statute of limitations tonight for obvious reasons. That's what everybody's been litigating up till now. So you'll have more defenses if you end up back in district court on breach of fiduciary duty in 2014. My colleague's just trying to get you to focus on whether that's an independent act of potential professional negligence that could be actionable. You're saying not by the Phalens, we
Right.
get that, but it's not a statute of limitations problem, is it?
But I think it does Your Honor, I don't think you can look at that actionable negligence in a vacuum and say it is or it isn't without looking at the statute of limitations as it relates to the Phelan's. If it was an independent cause of action in 2014, the Phelan's causes of action against my client are still barred because those arose in relation to the 2008 transaction, not the 2014 transaction.
Counsel, would you agree that with the 2008 transaction, that at least one injury that Phelan suffered was the need to do the equitable reformation? I mean, once that deed got filed, they had a right to go to court and reform that deed, and if they didn't, they were going to lose their mineral rights. I mean, there's a ticking bomb at that point, right?
There is, Your Honor, but I don't know if you would necessarily have to do reformation of the deed. Mr. Dean may have quitclaim deed or issued a deed back.
I understand that, but let's assume that the Phelans had to go ahead and pursue a reformation action. They had a legal right to do that at that time, and if they had to do it, the money they spent to hire a lawyer to fix your client's problem is an injury, right?
Presumably, yes, Your Honor.
We've asked enough questions to keep you from even getting to the question of reasonable ascertainable, and I have a question related to that. Based upon the case law that you have cited even, doesn't the fact that there was at least again, this is an allegation, but an allegation that there was a fiduciary duty, doesn't that change your constructive knowledge argument so that the Phelans had a right to rely on their fiduciary to have done it correctly?
And I don't think that changes the analysis in this case, Your Honor. And the reason I don't think that changes the analysis in this case is because of Kansas statutory law 582202, which provides that if a deed doesn't contain a reservation, then it passes the estate in total. The law in Kansas is that individuals, the citizens of Kansas, are charged with knowledge of the law and the legal effect of their actions. That is a statute in Kansas. I think the Phelans would be charged not only with constructive knowledge of the effect of the deed itself, but with that statute as well, Your Honor. So I don't think the fact that there's a fiduciary relationship changes that analysis.
Do we have any further questions? Counsel, would you like 30 seconds to wrap up, or do you want to wait
Your
till
Honor,
rebuttal?
I'll wait till my rebuttal. Thank you.
Very well, thank you.
Mr. Chief Justice and Justices, may it please the Court, Gordon Stull, appearing on behalf of the Phelans. I'll just lump them up as the Phelans, as we've always called them for the last several years. I would like to first address the issue about basically what the trial court did, and that is the trial court fundamentally relied only on constructive notice to make a determination about the statute of limitations. The trial court relied solely on the fact that a deed had been given and recorded as being the reason for summary judgment to be enforced against our clients. The problem with using that's 582222 as constructive notice as foreclosing my client's rights is twofold. One, in KSA 60-501, it says that that's the statute of limitations section in the Civil Code. I know you know that, but it says that the terms of the code cannot be varied except by a statute that specifically states it's modifying that code. And in fact, what they want to do here is utilize a recording statute to create constructive notice to modify the 2-year statute of limitations that my client has as a matter of law on negligence and on fiduciary duty, and the fact that should not be allowed to be done.
Isn't your better argument that constructive notice from recording is for the rest of the world? that when you have two people to the contract, the Phelan's and the Dean, that they should know what their deal is and what was done. And the purpose of recording in the Register of Deed is to give notice to the rest of the world, not notice to the parties to a contract.
Right, and I agree, Justice. And I was just wanting to point that out. And in fact, it's always boggled our mind in this case that our clients are always have it thrown at them that this constructive notice, they should have known what's going on, because once it was recorded, the whole world knows it. Well, if the whole world knew it, why didn't RCAT knew it, and why didn't they do something about it?
If you're going to mess up, you better rush on down and get that deed filed.
Yeah.
That's what it amounts to. What's
What-
problem number 2? You said there were 2 problems with the 58.
The other problem is in the series of cases that have been developed by the court. I think the last one is the 2013 case of Michaelis versus Farrell, which talks about ascertainable, reasonably ascertainable, and what they found. And this is consistent with what the Court of Appeals did. They relied on these series of cases, which says if you have an issue about that, you don't focus on one single thing, you focus on the whole context of the situation surrounding whether or not the statute of limitations, something happened that would kick it off. And when you do what he did, and that is just rely on constructive notice of one deed, one thing he ignored everything else is for one. And the other is, those cases say that the standard is an objective standard. And in other words, what did that person know? What was in their mind? What did they see? What did they hear? What did they know? What did they feel? But the problem with constructive notice, if there was a definition of subjective knowledge, it would be constructive notice. Constructive notice gives you no knowledge. It just pegs you legally with having the legal responsibility about it. So not only do they avoid that, they end up denying the court looking at the objective actions and what my clients knew.
If we're going to talk about the entire circumstance, all of the circumstances, totality, then what do we do with the fact that the deed was in the possession of your clients or their predecessors in interests for 2 days and that they signed it? So, I mean, we're talking a lot about constructive notice at the instigation of your opposing counsel, but what about actual notice and being put on notice they should investigate or ask a question?
Well, they got that deed from people they hired to produce and prepare that deed. They hired RCAT to handle the real estate transaction, to handle the deed preparation, to handle the title examination, and to handle the closing. It was their deed. We did not prepare that deed. RCAT prepared that deed and gave it to us. We had our client had a fiduciary relationship with RCAT, as RCAT being a title insurance or title agent, as in the Ford versus guarantee case, and so we just think that it was not our responsibility. I mean, I guess we could have the responsibility of going and hiring another lawyer or hiring another abstract company to make sure our abstract company did it right, but they thought they did it right. The district court made a specific finding that there is nothing in the record to indicate that our clients knew that there was a mistake or that that was wrong.
I can understand an argument that a layperson may not know that a legal description that places the surface someplace on the globe would also carry with it all the minerals underneath. And, you know, that's an argument you could make, but what do we do with the presumed to know the law? If we're going to use an objective standard, wouldn't an objective person be presumed to know the law and know that the surface description carries all the way from the sky to the center?
Well, one, I'm not sure that I would agree that my clients were presumed, or in this situation, my client should be presumed to have known the law. I think in this situation, they had an agent. It would have been presumed in the law for their agent to know the law, for their agent to know how to prepare a deed. If they wanted to have been responsible for preparing that deed, they'd have done it themselves.
But I've just struggled with this case so much because I don't understand why. I can understand a legal description or a meets and bounds kind of problem, that someone would stare at the page and not know that there was a problem. But this is a reservation of mineral rights in a document, and your clients signed it. And so when the question is whether it's reasonably ascertainable that there's a problem, you know, I'm reminded of the case that we just decided about the limestone mining underneath the ground, the Bromley case. You know, when the dishes start to shake in the house because they're blasting under your house, it's reasonably ascertainable that something's happening. And I don't understand why your clients wouldn't have an obligation under the reasonably ascertainable standard to do something, to ask, to go look. And they didn't do anything.
Well, first of all, let me say, because of the court's ruling giving a summary judgment to the other side, my client was deprived of the right to have a trial and put all these facts and all this other information in front of the court so the court could make a decision over all of the facts, not just the presence of deed. You know, the judge, I think, editorially added that he thought anybody could figure out that the minerals weren't included in that deed. Well, let me tell you, you may have guessed, I've done this for a long time, and I've done a lot of mineral reservations and deeds. And the one thing that I hear over and over is if somebody is selling minerals, okay, or is buying minerals, I should say, and you give them a deed, and all it is a legal description, and there's nothing in it that says minerals included or this and other, they think you haven't done it right. They think something has to be there to say, oh, the minerals are included. They don't understand the bundle of sticks deed.
Which makes my point that there was something reasonably ascertainable, and these other people in your hypothetical are holding their hand up and saying, why isn't this stuff here? And then they get an answer.
But we have,
all I'm saying is,
we have the converse here. My client is selling minerals. When you're selling minerals, if you're under that understanding, you wouldn't have a mineral statement. You wouldn't say including the minerals. There were no minerals mentioned, so it was reasonable for my client to think that the minerals weren't included. These are lay people. These are lay people. And besides that,
I think what you're trying to say with your example, you kind of lost me, but I think I've got where you are, that when you sell the whole thing, minerals included, you don't reserve the minerals, you just list the surface.
Right.
And the buyer goes, well, I wanted the minerals with it, and you didn't include it. And you're saying that it's not common knowledge for people to know the surface description includes the minerals. That's what you're trying to argue, isn't it?
absolutely.
Okay.
Absolutely.
You kind of lost me there, but
Sorry.
I think we're back on the same page.
Yeah. No, that's why. Anyhow, I think if the court had given the opportunity to look at the whole picture, like the Court of Appeals says should be done, then the court could understand all of that. And again, my client should not have been put in a position of being the one to decide, is this deed right? That was RCAT's responsibility. My clients did not prepare a deed. RCAT did. And they accepted that they had done their job. And to get to the 2014, they had no reason to suspect otherwise. They continued to get their royalties. The only thing my clients lost was record title. Record title. That's it. They only owned minerals before. They still possessed those minerals. They still acted as if they had the right to continue with the lease with the oil producer, the right to receive the checks. The oil producer paid them regularly.
They paid the taxes? They paid the taxes? They did the internal transactions among
Their name was
themselves?
on the renditions filed with the county, so they continued to pay the taxes over and over. In fact, my clients found out about this after the LLCL deal, when LCL tried to get the oil company to stop paying my client.
Right.
that oil company said, there's something fishy here, we're not going to do that, we're just going to suspend the royalties, and that's what prompted all of this.
Mid-August 2014.
Right, but ARCAT had two opportunities. They had the first opportunity to do it right, and then when they examined title on the LCL Sammy Dean transaction, what happened was they didn't notice or didn't understand the transactions that were from my clients to other family members dealing in minerals. If ARCAT had believed that my client owned no minerals, that would have been flashed on the title commitment that, hey, there's a stray deed here about these minerals rights. You know, you can't, that didn't happen.
Were there title commitments for those transfers? I thought they were kind of
no.
transfers among family members.
No, yeah, I'm sorry. I'm talking about when they saw those transfers and then put them on the title commitment for the LCL deal, okay? They didn't hit them. And as you suggested, anybody who does anything that has producing minerals, if you're doing title work, the one thing you want to know is, well, it's producing, who's getting the money, and does who's getting the money match who I find out ought to be getting the money? That's an easy check. You go to the treasurer's office and you go to the appraiser's office.
Do I recall that the title insurance identified that lease as being a producing lease?
Yes.
Okay.
Did the Phalens have the right to transfer their interest after 2008, but before the sale to Dean's in that interim period? Could they have sold their mineral right to someone if they didn't possess it? How would that have worked?
Yeah, well, they could have if somebody was dumb and didn't check title, but I think it would show up. If something had happened.
So when the injury occurred is when? When they would have tried to transfer it, or in 2008 when they didn't receive proper title?
I think you have to talk, there's where you get into this idea of injury and substantial injury. And the loss of record title, especially under the totality of circumstances, clearly was not a substantial injury. Nothing happened to them. They were happy.
Well, it was a substantial injury. Wasn't it? Because your argument is that it's not a reasonably ascertainable injury, or are you arguing both?
Both. Yeah.
If the deed from Dean to LCL LLC had reserved that minerals interest, then your clients still wouldn't be harmed. It'd still be getting the minerals interest, it'd still be having full enjoyment.
Right.
It just, it'd be oblivious to the fact that the title was messed up there along the way, but they would still have full enjoyment of the property.
They would have, and had ARCAT, when they were doing their examination and talking with Sammy Dean and LCL about that transaction, had they done their title work right, and had they notified my client of the mistake, Sammy Dean testified in deposition that if he'd have known that, he would have deeded it back over any time, because he had no claim to it, didn't want anything to do with it. He would have given it back to him. All they had to do was to disclose to our clients what they knew during the LCL transaction. They didn't. They hid it. Not only did they hide it, the evidence would be that they helped LCL structure the transaction so that Sammy Dean, who said, you're not getting any minerals with this deal, signed the same kind of deed that didn't reserve or say no minerals, so that it was fee title, so that LCL could grab on to my client's mineral rights and do that. Well, and then what happened is LCL decided to get that transfer, and when he couldn't get the royalty, he made a claim against ARCAT, or First American Title. And so then they weighed their odds. Which is the better case for us? Fighting LCL on this for giving them a bad title commitment, or sticking it to the Phalens by telling them they are barred by the statute of limitations? Well, and they decided to go to the LCL and pay them. They paid their attorney fees to try to take our minerals away. That's what we've been fighting.
Do we have any further questions of council?
One question. The reference a moment ago to whether you're arguing that there either was no substantial injury in 2008, or that whatever substantial injury occurred was not reasonably ascertainable at that time. I just want to get clear in my head what you think our standards of review are on those questions. Is the existence of injury a question of fact? Whether it's substantial enough to qualify for substantial injury in the statutory language, is that a question of law? And then reasonably ascertainable? Where are we here?
Well, the cases that deal with those issues say that when there's a dispute about or conflict in the facts about those issues, it's to be decided by the trier of facts. That's why we should have had a trial here.
Okay, thank you.
We have any further questions? Did you need any more time to wrap up, or do you think you've made your points?
Yeah, I think I'm fine.
All right, thank you, counsel, for your candor.
May it please the court. We spent a lot of time discussing the reasonably ascertainable under 60-513 and whether or not the Phelan's injury was reasonably ascertainable in 2008, 2014, and when they suffered injury. But there's another part of 60-513 that I think is very instructive in this case and in Kansas law, and that is subsection 3, where it discusses a cause of action for fraud. And the statute says, an action for relief on the ground of fraud, but the cause of action shall not be deemed to have accrued until the fraud is discovered. This court has repeatedly held that actual knowledge is not required under this subsection, that constructive knowledge imparted by KSA 58-2222 is sufficient to cause the statute of limitations to accrue when the fraud occurred. Not that it's reasonably ascertainable, but that it's discovered. Discovered is a more imposing standard, Your Honors, than reasonably ascertainable. But this court in Black v. Black 100 years ago said that the statute of limitations for 2 years and a cause of action for fraud occurs when the fraudulent conduct occurred. And that's in preparation and the filing of a deed, because the public is charged with constructive notice of what's in that deed.
And do you add to that, as Justice Johnson suggested, then we have to add the next step of, then we presume they know the law and understand what that deed transfer meant?
Yes, Your Honor, and I think you do, because that's what you do in a fraud case. If you were to hold that the Phelans in this case can come in and say, well, we understand that the deed, or we didn't understand the deed, didn't include our mineral interest reservation, you would have that defense in every case based on fraud, that somebody could come in and say, when a deed is filed, I didn't understand what the deed said. I didn't understand the meat and bounds. I didn't understand the legal description. I didn't understand that I was conveying this property. So you basically vitiate the constructive notice created by the statutory law, 58-2222.
And you vitiate the contract, because we're talking what happened in 2008 was between the Phelans and Dean. And they had a contract, and they made a deal to sell the land without the minerals, and completed that transaction. They both knew what they were doing, knew what they were paying for, knew what they were getting their money for, and the mistake on the deed basically vitiated the right of two people to contract a deal.
Well, Your Honor, I don't think it's as easy as it just vitiated the contract between the two parties. I think if this court were to hold that the Phelans can come in and say, I didn't understand that I didn't reserve my mineral interest when I looked at this deed, I had 2 days to review it, and I signed it, and every other document in this case references reserving the mineral interest, but I didn't understand this deed. That would have opened the Pandora's box in terms of fraud cases and cases in the future where a party's charged with constructive notice of what's the content of the deed or the content, because they're going to be able to come in and say, I didn't understand it. So constructive notice created by the legislature has no purpose.
Well, counsel, the disconnect I'm having, I understand the constructive notice argument, and you're right. operates as a matter of law to charge a party with knowledge. It's a legal fiction, if you will. But the legislature chose the language reasonably ascertainable in our context. And that's the disconnect I'm having. Reasonably ascertainable suggests to me that it involves a kind of factual totality type analysis of a reasonable person. And can we make that leap from the legal principles of constructive knowledge to what really amounts to a kind of factual inquiry?
And I think you can, Your Honor, and that's why I was talking about subsection 3, where you talk about fraud, or where the statute talks about fraud, and that a cause of action for fraud accrues when the fraud is discovered. And this court, almost over 100 years ago, held in Black v. Black that constructive notice imparted by the filing of a deed is sufficient to start the statute of limitations in a fraud case where it requires actual discovery. Here you're just talking about an objective standard of whether or not something is reasonably ascertainable.
That actually makes some sense to me when you talk about actual discovery, because now we're talking about what's the legal impact. Whereas I guess I'm asking you to connect the dot to reasonably ascertainable.
And the connection of the dots, Your Honor, is that reasonably ascertainable is a lower standard than actual discovery. And if you look at the language of this court in Black v. Black, the court stated discovery does not necessarily mean until the party complaining had actual notice for constructive notice. It's sufficient to set the statute in motion even though there may be no actual notice. And this is in the context of fraud. And where the means of discovery lies in the public records required by the law to be kept, and which involve the very transaction in hand and the interests of the parties to the litigation, in such case, the public records themselves are sufficient constructive notice to set the statute in motion. That's this court's language in Black v. Black.
But 8 years later, in Hutto versus Knowlton, they said, if a fiduciary relationship exists requiring disclosure of the true state of facts, the obligation to search the records is relaxed.
And that's
So
true.
what do we do? I mean, doesn't that goes back to my question to you earlier, doesn't that offset that constructive notice?
I don't think it does, Your Honor. I don't think it does offset that constructive notice. While the situation may be relaxed, the buttress to that in this case is the fact that the Phalens actually had that deed in their hands for 2 days and had the opportunity to review it. So it's not just a matter of constructive notice imparted by the statute, it's the fact that they had the deed and had the opportunity to review it.
It
But
means
the
they
pleadings
displaced-
show-
Go ahead.
The pleadings show there's a clear dispute on what happened with that deed in those 2 days. How much they reviewed it, how much they read it, et cetera. I mean, there's a dispute of fact, and that kills summary judgment.
I don't think that kills summary judgment, Your Honor, because the law in Kansas is if a party to a contract, which basically a deed is a contract, if a party fails to read that contract before they sign it, they're charged again with notice of what's in that contract. If the Phalens did or didn't review that deed, they had the opportunity to do so. Whether they chose to do it or not is not dispositive as to my client and whether or not my client sent it to them. They had the opportunity. Whether they chose to or didn't choose to is not negligence on the part of Rice County Abstract and Title. For these reasons, Your Honor, we'd ask that the judgment of the trial court be affirmed.
Do we have any further questions?
I do.
Yes. Counsel?
Yes.
I'm confused. If someone has a document in their hand for 2 days, looks at it and signs it, why are we talking about constructive notice of what that document says when they had it in their hand and looked at it?
Because-
Why does that statute have any more force and effect than actual knowledge? Because they had actual knowledge of what the deed says. So why are we talking about constructive knowledge of what the deed said when we have someone with actual knowledge?
Because, Your Honor, and I think then the disconnect, and it probably goes back to one of the earlier questions in this case, is under 60-513, it's a two-part inquiry potentially. The first is did the party have an injury? And if they had suffered an injury, the statute of limitations begins to run from the date of that injury. Or if the injury is not reasonably ascertainable, it begins to run when the injury is reasonably ascertainable. We moved for summary judgment on both of those grounds, that if the Phalens didn't know about the injury because they failed to read the deed.
I understand all of that, but are you saying that constructive notice of what the document said carries more force of law than actual knowledge of what the document says?
No, Your Honor, I think they're on equal footings here. I think it can be either or. You can have actual knowledge of what the document says, or you can have constructive
And
knowledge.
they had actual knowledge here because they had it in their hands. So what does constructive knowledge have to do with the price of wheat in Kansas right now? I mean, really, because we had actual knowledge.
Fair enough, Your Honor. And if you look at the court's opinion in Bi-State, that's the case that we moved for summary judgment at the trial court level in. Bi-State applied constructive knowledge based on the statute on an easement, and so that was the reason that was an issue. And in that case, basically, the Court of Appeals held that it didn't matter if you were an expert at reading easements or whatever. You're charged with constructive notice.
So actually, constructive notice gives notice of what the legal effect is what you're saying. They could have actual knowledge of what it says, but once it's recorded, then they're charged with the knowledge of what it means.
Yes.
Is that what you're saying?
That's essentially our argument, Your
All right.
Honor.
Thank you.
Thank you.
Any more questions? Thank you, counsel. We thank you both for your arguments this evening. Court will take this matter under advisement